Maricopa County, Scottsdale, Arizona. A Wednesday morning in late April. The kind of morning the desert does before the heat becomes the whole story. Clear air, long shadows from the saguaros at the property edge. The light coming in at an angle that makes everything look slightly more geometric than it is. Gravel and scrub, and a dirt access road that runs from the paved county road about a quarter-mile to a chain-link gate with a construction notice zip-tied to it. Beyond the gate, surveying stakes with orange flags in the ground at irregular intervals. A folding table near the center of the cleared area with a set of rolled plans and a laptop in a case. A truck parked near the table with a contractor's magnetic sign on the door. The contractor, a man named Hector, had arrived at 7. The man he was meeting had arrived at 7:15 and had been walking the staked boundaries with a copy of the survey map when the Scottsdale PD cruiser came down the access road at 9:42 a.m. The man with the survey map was named Blake Donovan, 46 years old. He had been a real estate developer for 19 years. He had purchased this parcel, 43 acres of desert edge land in unincorporated Maricopa County, 8 months earlier through a land trust and LLC structure that was standard for development projects of this size, and that had been properly recorded with the county assessor's office, and was searchable in approximately 4 mouse clicks by anyone with an internet connection and a reason to look. Officer Mason Rourke had not looked. He had received a call at 9:35 from a number that dispatched logged as an anonymous tip. A woman who said she'd driven past the access road and seen a man on the property who she didn't think was supposed to be there. She hadn't said why she thought that. Dispatch had logged it as a possible trespassing report and sent the nearest unit. Rourke was 35, 6 years on the force. He'd worked the Scottsdale North District for 3 of those years, which covered a stretch of land that included a lot of high-end residential and commercial development, a lot of active construction sites, and a corresponding frequency of trespassing calls that ranged from legitimate to neighbor disputes to exactly this: someone driving past something and deciding that the person they saw didn't match the place they saw them. He had processed enough of those calls to know the pattern. He had not, apparently, processed enough of them to know what to do when the pattern was wrong. He came down the access road and got out of the cruiser and said what he said, and Blake said what he said, and here they were. "Who called this in?" Blake said. "I'm not going to share that information." Was it a report of specific criminal activity or a general suspicious person call? Rourke looked at him. "I need you to explain your presence on this property before I answer your questions." "That's backwards. You need to explain your authority to remove me from this property before I explain my presence." "My authority is..." "A trespassing call requires the property owner or their authorized representative to request removal. Do you have that request?" The call indicated, "Do you have a request from the property owner?" Rourke looked at his radio, then at Blake. Blake was holding the survey map, folded to the section showing the current parcel boundaries, with the county recording stamp visible in the lower right corner. He had the map in one hand and a coffee in the other, in the way of a man who had been here for 2.5 hours doing ordinary work, and had not expected to spend part of his morning having this conversation. Hector was at the folding table, 20 yards away. He had not moved toward the scene and had not moved away from it. He was doing the specific thing that contractors do when a property owner and a police officer are having a disagreement on their job site, staying in his lane and watching carefully. "I need to see identification," Rourke said. "What's the legal basis for the ID request?" "Possible trespassing." "You haven't established trespassing. You established that someone called. Who called doesn't tell you whether the person you found is trespassing. You're on private property." "I know. Without apparent authorization." "Without apparent authorization to you. That's different from without authorization." Rourke looked at the survey map, at the construction stakes, at the contractor's truck, at the folding table with the plans. He was doing the visual inventory of someone who is trying to find something that supports what he arrived with, and the inventory was not producing what he needed. Stay with this, because the next decision is where a 6-year career begins to develop a crack it can't close. A second vehicle came down the access road at 10:03. Not a cruiser, a white pickup, contractor plates. A man who got out and nodded at Hector, and started toward the table before he noticed the cruiser and adjusted his path toward the scene instead. His name was Dave. He was the structural engineer who had been scheduled to walk the site at 10. He had been on this property twice before, once during due diligence and once 2 months ago when the preliminary surveys were being confirmed. He looked at Blake, at Rourke, at the survey map in Blake's hand. "Everything okay?" "Working on it," Blake said. "Officer," Dave said to Rourke, in the tone of a man who has worked construction sites long enough to have interacted with law enforcement at them, and who has opinions about how those interactions should go. "What's the issue?" "Property access," Rourke said. "It's his property. That's what he's telling me. That's what the county assessor's records will tell you too." Dave put his phone away. He'd pulled it out when he walked over. Blake had sent him a text at 9:50 asking him to look up the parcel recording when he arrived, because Blake had understood 3 minutes into this conversation that it was going to require documentation he hadn't planned to provide, and he'd started building toward it. Parcel 214-77-003. Blake Donovan, owner of record through Sonoran Land Holdings, LLC. Recorded 8 months ago. You can pull it on the county assessor's website right now if you want. Rourke looked at Dave, at Blake, at the phone Dave was holding with the assessor's page already pulled up. He didn't look at the phone. "Sir," Rourke said to Blake, "I'm going to need you to step over here while I verify." "Verify on the phone Dave just showed you." "I verify through my own channels." "Then use them. I'll stand right here." "I'm asking you to step to the cruiser." "I'm not going to the cruiser. I'm standing on my own land talking to you while you figure out something you could have figured out before you came through the gate." Blake set his coffee on a nearby stake marker. "Not hard, just set it down." "Call your dispatcher. Ask them to pull the county assessor record for parcel 214-77-003. That's the parcel number. It's public record. It takes 30 seconds. Rourke looked at him for a moment. Then he picked up his radio. He didn't ask dispatch for the assessor record. He called for backup. Officer Zachary Pike arrived at 10:19. He came down the access road and got out and read the scene. The cruiser, the contractor vehicles, the folding table with the plans, the structural engineer standing near the gate, the man with the survey map who was standing in the middle of his own property and had been standing there for 37 minutes. Pike looked at Rourke. "What are we working with?" "Possible trespassing. Subject is not cooperating with relocation." Blake turned slightly at the word relocation, not toward Pike, toward the middle distance, the specific direction a person looks when they've heard something that deserves a response, and they're deciding how much of it to give. "I'm not a subject, and I'm not being relocated. I'm the property owner, and I'm standing on my land." "He says he owns the property," Rourke said to Pike. "The county assessor's records confirm it," Dave said from his position near the gate, holding up his phone. "I showed him the page 20 minutes ago. He didn't look at it." Pike looked at the phone, looked at Rourke. "Did you pull the record?" "I was waiting for..." "What parcel?" 214-77-003, Blake said. Pike pulled out his own phone, typed it in. The Maricopa County Assessor's website loaded in 4 seconds. He read the screen, read it again, looked up, looked at Rourke. Something passed between them that didn't need words. Pike put his phone in his pocket. "Mason, can I talk to you for a second?" They went to the cruiser, not far. The cruiser was 20 feet away and the conversation wasn't inaudible, but it was quieter than the main scene. Pike's body cam was running, so was Rourke's. Both would be reviewed. What Pike said, in a lowered voice that both body cams partially captured. "The parcel's registered to him. It's right there on the assessor's page. His company. His name is manager. Recorded 8 months ago." What Rourke said. The call said someone saw a person on private land. That's it. That's all the call was. He wasn't cooperative. He asked for the legal basis. That's not non-cooperation. That's a question. A pause. "Mason, he owns the land." What Rourke said after the pause, the part that both body cams caught clearly enough that the IA review board would play it twice, was, "He didn't look like he owned it." Pike said nothing for 3 seconds. Then, "We need to clear this." They came back. Rourke looked at Blake. "We've confirmed the parcel registration." "I know," Blake said. "You're free to continue on the property." Blake looked at him. "I've been free to continue on the property for the last 41 minutes. Nothing changed about that. What changed is that you confirmed it." Rourke said nothing. "I want your badge number," Blake said. "Both of you." Pike gave his immediately. Rourke gave his after a 2-second pause that both cameras caught. Blake entered both into his phone. He looked at the survey map, looked at the orange stakes, looked at Dave near the gate. "Let's get to work," he said. He walked toward the folding table. Dave fell into step beside him. Hector had a set of plans already unrolled and waited at the corners with rocks. "Watch what the next 30 days produces, because he didn't look like he owned it, is now on 2 body cams, and nobody can take it back." Blake filed the formal complaint that afternoon. Not through a civilian complaint form, through his attorney, who had been in real estate development law for 22 years, and who had, in those 22 years, developed a specific set of practices for when a client called from a job site and described what Blake described. The complaint was specific, procedurally accurate, and attached to a timeline that the attorney had reconstructed from Blake's notes and the timestamps on the text messages Blake had sent during the stop, including the one to Dave at 9:50, asking him to look up the assessor record, which was time-stamped, and which established that Blake had been providing verification options for 20 minutes before Pike arrived and checked. The Scottsdale PD's Internal Affairs Division opened the review on day 3. The body cam footage from both cameras was secured on day 2, the department's standard hold protocol for stops, resulting in a formal complaint, initiated by the watch commander after reading the complaint summary and recognizing the phrase, "He didn't look like he owned it," in the preliminary incident report. The watch commander had put the hold on the footage before the IA review was formally opened, because he had been in law enforcement for 26 years, and he knew what that phrase sounded like in a formal record. The review board watched both feeds on day 4. They watched the full 41 minutes, from Rourke's cruiser coming down the access road to Blake walking toward the folding table. They watched Pike's arrival. They watched Dave holding up the phone with the assessor's page, and Rourke not looking at it. They watched the cruiser conversation between Pike and Rourke, enhanced by the technical unit to 62% audio clarity. The phrase came through clearly enough at 62%. He didn't look like he owned it. The board spent more time on that sentence than on anything else in the 41 minutes. Not because it was the only problem. Rourke's failure to verify before initiating the stop, his failure to check the assessor's record when Dave offered it, his radio call for backup rather than for verification, his use of the word relocation, all of those were in the findings. But the sentence was the sentence. It was the one that stripped away the procedural language and left the thing underneath. 6 words, caught on camera in a lowered voice 20 feet from the subject of the stop. The subject who had been standing on his own property for 41 minutes because Rourke had trusted an anonymous call over 4 accessible mouse clicks of public record. The board's findings were organized into 3 categories. The first addressed the stop's procedural basis. The anonymous call had not alleged specific criminal conduct, had not identified the caller, and had not provided information distinguishing the observed person from an authorized party. The board found that these factors, combined with the visible presence of contractors, professional equipment, and a survey map, should have prompted verification rather than a removal attempt. The second addressed the failed verification. Dave's phone had been visible and accessible. The county assessor's website was publicly accessible from any device. Rourke had called for backup rather than checking. The board described this as a deliberate choice to escalate the encounter rather than resolve it through available means. Deliberate choice. The language of a finding that has decided intent. The third addressed the cruiser conversation. The board quoted the phrase directly in the findings. It didn't contextualize it. It didn't explain it. It put it in the findings document under the heading Officer Statements and let it sit there, the way evidence sits when it requires no interpretation. Rourke's personnel file produced one prior complaint, a 2022 stop on a residential street where a black homeowner had been questioned about working on his own garage and had filed a complaint that was reviewed and closed with a counseling notation. The counseling notation was in the file. It had not produced material behavioral change. The board noted the prior complaint and the counseling notation in the pattern section of the findings. Pattern section. 2 incidents, same underlying driver, different setting, same 6 words and different forms. Rourke was suspended without pay on day 17. The suspension letter cited 4 violations: initiating removal from private property without verified trespassing complaint from the property owner or authorized representative, failing to verify available property records before or during the encounter, calling for backup rather than utilizing verification resources, and making a statement during the encounter that confirmed the stop was initiated based on the subject's appearance rather than observed conduct. That last citation quoted the phrase, the full 6 words, in the suspension letter under his name. His union filed a grievance on day 19. The grievance panel watched the footage. Specifically, they watched Dave hold up the phone with the assessor's page at 10:03 a.m., and they watched Rourke not look at it. They watched Pike look at it at 10:19 and verify the ownership in under 30 seconds. They watched the 16 minutes between those two moments, 16 minutes in which the information that resolved the stop was available on a phone that was being held up specifically for Rourke's benefit, and he had chosen not to use it. The grievance was denied on day 31. The termination recommendation came from the review board on day 22. The division chief approved it on day 26. The Arizona Peace Officer Standards and Training Board received the referral on day 29. Post reviewed the case on day 42. The footage, the findings, the prior complaint and counseling notation, the pattern section. Certification revoked on day 51. His appeal was filed on day 64. The appeal panel watched the footage. They watched it at the moment Dave held up the phone. They watched Rourke's eyes. They did not go to the assessor's page. The appeal was denied on day 80. Pike was not disciplined. His conduct at the scene, arriving, verifying immediately, identifying the problem, and attempting to correct it, was noted in the IA review as evidence of appropriate judgment. The board's report included a paragraph specifically commending his decision to verify independently rather than simply back up his partner's position. The paragraph went in his file. He kept a copy of it in a folder he didn't label. The caller who had made the anonymous tip was identified through the county's non-emergency line call log, which retained the number despite the caller not identifying themselves. She was a 61-year-old woman who had been driving past the access road on her way to a trailhead. She had seen a black man walking the fence line of a piece of desert land and had called because she thought something looked wrong. The city's legal team reviewed the call in the context of the stop. The caller had not alleged specific criminal conduct. The recording of the call was in the evidence file. The city determined that the call itself was not actionable. The caller had a right to report what she observed, but that Rourke's response to the call, and specifically his failure to verify before initiating removal, was the actionable element. The caller was not charged. She was not publicly named. The civil complaint did not name her, but the IA findings referenced the nature of the original call in the procedural section, and the city's subsequent policy revision, requiring officers responding to anonymous trespassing calls to verify ownership through public records before initiating removal, was drafted in direct response to what the call had produced. The civil lawsuit was filed 39 days after the stop. It named Rourke personally. It named the Scottsdale PD. It named the city. The filing cited the procedural failures, the 6-word statement, the prior complaint and counseling notation, and the 16-minute window during which verification was available and not used. The lawsuit also cited something the city's legal team had not anticipated, a clause in Blake's LLC operating agreement recorded with the county that contained a provision related to interference with development activities. Blake's attorney had included it in the filing, not because it significantly changed the legal landscape, but because it demonstrated, with a recorded document, that the development activity on the property that morning had been authorized, planned, scheduled, and professionally staffed, and that Rourke's characterization of Blake's presence as suspicious had no basis in any observable element of the scene. The city's legal team read the LLC filing, called for a settlement meeting on day 47. One meeting. The settlement was reached on day 62. $1.2 million. The structural conditions. Mandatory property verification training for all officers responding to trespassing calls, specifically covering how to access county assessor records in the field. Independent review of all trespassing stops in the prior 3 years in the Scottsdale North District. Revision of the anonymous call response protocol to require verification before any removal attempt. And the policy revision requiring ownership verification before removal, which had already been drafted, but which the settlement formalized into a written departmental policy with compliance tracking. Blake's attorney had one additional condition. It was in the first draft and stayed in every subsequent one. The department was required to add the case, the footage, the IA findings, and specifically the 6-word statement to its annual use of force and procedural training materials as a documented example of assumption-based enforcement, not as a disciplinary cautionary tale, as a training case. The city signed it on day 62. Blake went back to the property on a Thursday morning 6 weeks after the settlement closed. The project was moving. Foundation permits had been approved. Grading had started. The access road had been widened to accommodate the equipment that was going to need it. He drove down it in his truck and parked near what was becoming the building pad. He stood at the edge of it and looked at the site. Orange stakes still in some of the peripheral areas. A work crew at the far end. Hector's truck parked near the materials staging area. The morning light the same as it had been in April. Long shadows, clear air, saguaros at the boundary. He thought about the 16 minutes. Dave holding up the phone. Rourke's eyes not going to it. 16 minutes of a piece of public information being available and not used, for reasons that Rourke had eventually summarized in 6 words that he had probably said without thinking, the way people say the truest things, without planning to, in a lowered voice, to a colleague, 20 feet from the person the words were about. He thought about what would have happened if Dave hadn't arrived at 10:03, if the structural engineer's appointment had been at 11 instead of 10, if Pike hadn't pulled out his phone and checked, if the stop had happened on a day when there were no contractors on site, no folding table with plans, no magnetic sign on a truck door, just a man walking the fence line of land that his LLC had purchased 8 months ago, and that he had a legal right to stand on. The answer was probably not 41 minutes. It was probably longer, and the documentation at the end of it would have depended heavily on what he'd been able to produce from his phone and his memory, rather than from the professional setting that surrounded him that morning. He wasn't sure the settlement would have reached 1.2 million without the 16 minutes on camera. He wasn't sure the 6 words would have been captured without Pike arriving at the right moment and Rourke choosing the cruiser conversation to say them. He wasn't sure the prior complaint counseling notation would have made it into the pattern section without an attorney who had been doing this for 22 years and knew exactly where to look. A lot had to line up. He watched a piece of equipment move across the far end of the pad. The work was continuing. It had been continuing since April. The stop had been 41 minutes on a Wednesday morning, and the project had kept moving, the way projects keep moving when their owner is still standing, and the permits are filed, and the contractors are professional, and the work has somewhere to go. He got back in his truck. He had a meeting in Tempe at 11. He drove out on the widened access road and turned onto the county road and headed south. The training case went into the department's annual materials 6 months after the settlement. Not the full footage, excerpts, reviewed by the department's legal division for privacy considerations, with the identifying details of the subject redacted except for his role as confirmed property owner. The 6 words were in it, not redacted. In the training materials under the section heading, "What Assumption Sounds Like on Camera," officers who watched the training would hear the phrase in context, the lowered voice, the cruiser, Pike's silence after it, and they would hear it after watching 16 minutes of a phone being held up and not looked at. The training didn't tell them what to think about it. It showed them what it looked like, what it cost, what it said on 2 cameras in the middle of a Wednesday morning on a dirt access road in unincorporated Maricopa County. It said it in 6 words, and now those 6 words were in the training materials, attached to a case number, attached to a settlement amount, attached to a policy revision, attached to an officer whose certification was revoked on day 51. That was the cost. 1 property inspection, 43 acres of desert land, 41 minutes on a Wednesday, and 6 words. If stories like this one matter to you, subscribe. Because the ones where a man is standing on his own land and still has to spend 41 minutes proving it are the ones that need the most documentation. And most of them never get it.